Hello and welcome. This video, Some Planning Suggestions for Revocable Trusts, is the third in a series of 10 videos designed to educate Utah residents about estate planning. For a list of all of our videos, see below or return to our website. In this video, we offer some suggestions on how to structure your revocable trust. For more detailed information, please feel free to visit our website at utahtrustsandestates.com. As described in video number 2 of this series, revocable trusts, also sometimes known as living trusts, are terrific vehicles for avoiding probate. Indeed, that is why they were invented. Historically, when a person died, all of his or her assets were subject to a court-supervised probate. In probate, it was the court's job to make sure that all of the estate's net assets were properly distributed to the estate's beneficiaries. But probate was a lengthy, expensive, and inconvenient process. Accordingly, revocable trusts were readily embraced when they were introduced on a large scale in the 1960s as a novel method for avoiding probate. And the Uniform Probate Code followed suit when it adopted greatly streamlined probate procedures. Utah has adopted the Uniform Probate Code. However, in a sense, revocable trusts have made it too easy to move assets to the next generation. Revocable trusts are still the best alternative, but there are some issues to be aware of. As a trust and estate attorney, I frequently receive phone calls from beneficiaries whose parents' estate plans have gone awry. The following scenario is typical. Mom and dad have several children. One of the parents dies and the other parent gets on in years. The surviving parent comes to rely on one child more than the others. Perhaps that child has more financial experience than the others. Perhaps he or she is the primary caregiver. Perhaps he or she is simply the child who lives closest geographically. Whatever the reason, that child is named as the successor trustee in the revocable trust. Often, assets mysteriously migrate from the parent to this child, perhaps during the parent's lifetime, perhaps after death. Sometimes this occurs with the other children's knowledge, sometimes not. There is often at least a cloud of suspicion. In other cases, the estate plan may actually be modified in a manner that benefits this child, again, often without the other children's knowledge, until it's too late. After the surviving parent dies, this child serves as the successor trustee and often fails to provide the other beneficiaries with the information to which they are entitled, and generally treats the trust property as his own. He either walks away with the trust property or dispenses small amounts to the other beneficiaries as and when he chooses, all in blatant violation of his fiduciary duties. Sometimes this child acts out of ignorance, sometimes with unscrupulous motives. In some cases, a lawsuit follows. In others, the other family members just give up and let that child get away with it, either because they lack the resources to fight or because they don't want to create tension in the family. If the parent becomes incapacitated before death, the fully funded revocable trust successfully avoids the need for a conservatorship. But if the successor trustee does not understand his responsibilities or is determined to engage in self-dealing, the same problems can arise. The combined effect of the popularity of revocable trusts and the streamlined probate procedures under the Uniform Probate Code is that trustees and executors have unprecedented freedom to administer trusts and estates as they see fit, without being answerable to the court unless a beneficiary files an objection with the court. Unfortunately, that also means that trustees and executors have unprecedented freedom to breach their fiduciary duties with impunity because the other beneficiaries often fail to enforce their rights. While making the succession of a decedent's property less burdensome may have been a worthy objective 50 years ago, the pendulum has perhaps swung too far in the other direction. The problem of trustees ignoring their fiduciary duties and getting away with it has grown exponentially in recent decades. One solution to this problem is to structure your successor trustees in a way that provides checks and balances, rather than giving your trustee too much power. During your lifetime, you will typically be the trustee of your own revocable trust. Upon your death or incapacity, the person you name as successor trustee in the trust instrument will become the trustee. The successor trustee will hold legal title to the trust property and will control the trust property subject to the fiduciary duties he or she owes to the trust beneficiaries. These fiduciary duties include providing the beneficiaries with a copy of the trust instrument, sharing a complete inventory of the trust assets with the beneficiaries, preparing an accounting of trust income and disbursements, and distributing the trust assets to the beneficiaries once all creditors and taxing authorities have been paid. But there is no guarantee that the successor trustee will perform his obligations. Successor trustees of revocable trusts will typically be individual persons, such as family members, friends, or professional advisors. Because institutional or corporate trustees charge for their services, individuals are usually selected to serve as successor trustees in order to save money. What can be done to rein in a trustee? The following are some suggestions. Suggestion number 1. When your attorney drafts your revocable trust, you might consider designating 2 or perhaps 3 successor co-trustees who can keep an eye on each other, and requiring that they must act unanimously. Having more than 3 trustees can be unwieldy, but 2 or 3 is usually manageable. Appointing multiple successor co-trustees can significantly reduce the danger that your successor trustee will undermine the estate plan you have put in place. Suggestion number 2. Of course, even if you appoint multiple successor trustees, the possibility exists that one trustee will call the shots and the other trustee or trustees will take a back seat. That's why it's important to select qualified trustees. Not every trustee needs to be an experienced professional, but all trustees should be individuals who are smart, conscientious, and reasonably sophisticated. If your children do not fit that description, consider appointing another family member or a trusted family advisor. Suggestion number 3. Successor trustees are usually family members, but you might consider designating an independent trustee. Appointing a co-trustee who is not a beneficiary and who has no financial expectations or emotional involvement in the estate can help safeguard against the problems that may come with having a family member or beneficiary serve as trustee. Suggestion number 4. Most families do not want to hire banks or trust companies because they charge for their services. Nonetheless, for the reasons I've already described, in some circumstances, an institutional trustee may be well worth the cost. Another option is to select a private professional trustee. Private professional trustees are individuals, often retired trust company officers, who are available to serve as fiduciaries at a lower cost than what institutional trustees charge. Selecting an institutional or private professional trustee can dramatically reduce the risk of mismanagement or malfeasance. One technique for holding the trustee accountable is to include provisions in the trust instrument that impose specific requirements on the trustee and specific penalties for failure to comply with those requirements. All trustees must give the trust beneficiaries an inventory of the trust assets, must prepare an annual accounting for the beneficiaries, and must distribute the trust assets to the beneficiaries in a timely manner. But the law does not impose specific deadlines. You may want to talk to your attorney about some of the following possibilities. The trust instrument could require that the trustee provide a full, detailed inventory of all trust assets within 120 days after your death. The trust could require that the trustee provide annual accountings to the beneficiaries within 60 days after the end of each calendar year. The trust instrument could require that the trustee distribute all trust assets to the beneficiaries within 1 year after your death. If the trustee fails to perform these specific obligations, the trust could provide that a majority of the non-trustee beneficiaries can remove the trustee without first obtaining court approval. An additional remedy may be to provide that if the trustee fails to meet these deadlines, the trustee may not receive any compensation for his services as trustee, or if he is a beneficiary, that his share of the estate is to be reduced. The trust could also provide that if the trustee fails to meet these deadlines without good reason, the trustee's legal fees in defending against his removal must be paid by him out of his own personal funds. And if the trustee is also a beneficiary, the trust instrument could also require that the legal fees of the other beneficiaries be deducted from the trustee's share of the trust. Finally, sharing information with your beneficiaries during your lifetime can help ensure that your estate plan will be implemented as intended. Discussing the contents of your estate plan with family members during your lifetime can help relatives who are not happy with the plan understand the rationale behind the plan, reducing the possibility that they will contest the plan after your death. And telling all of your beneficiaries in advance what they are to receive gives them an opportunity after your death to enforce their rights against trustees who do not fulfill their duty to keep the beneficiaries informed. Similarly, providing your primary beneficiaries with an itemized list of your assets can thwart an attempt by a trustee to hide or siphon off assets. If your primary beneficiaries are told the extent of your property during your lifetime, they can make sure it is all accounted for after your death. It may therefore be advisable to give a copy of your estate plan to all of your primary beneficiaries during your lifetime, to discuss the estate plan with your primary beneficiaries, and even with relatives who are not beneficiaries but who think they should be, and to give your primary beneficiaries an itemized list of all of your property during your lifetime. That concludes this video. I hope you have found it helpful. For more information on this topic, you can visit our website at utahtrustsandestates.com or call us at the number you see on your screen. If you would like to watch another video in the series, either click on the appropriate link below or return to our website. Thank you.